Time is the only thing any of us has that is not of infinite availability. If I, as the attorney, know, because it's true, if I find more things about which I can create drama, that I can create conflict, that I can create a fight, that I can create motions and discovery and litigation, I make more money. The firefighters become the arsonists. I am now not aligned with my clients. AI can liberate us from the stuff that's not really the practice of law. We're going to be able to serve our clients so much more deeply, so much more completely. It's going to restore what I think was the most honorable title we've ever been given, and which we've stripped from most of our business cards, which is attorney and counselor at law.
This is the Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadeo. My guest today is a visionary attorney, a legal business consultant, and a man on a mission to fundamentally change how law firms operate and how lawyers get paid. Christopher Anderson is the host of the highly respected podcast, The Un-Billable Hour, and the co-founder of multiple successful law firms, including New Leaf Family and Anderson Dodson. With a wildly diverse career that spans from prosecuting sex crimes in the Bronx to developing legal tech as a product manager for LexisNexis, he brings a battle-tested, deeply practical perspective to the business of law. Having lived the traditional law firm grind, he is today here to challenge one of the legal profession's most sacred cows, the billable hour. He joins us to share a roadmap for how litigators can ditch the timesheet, leverage new technologies, and build healthier, more profitable practices that deliver true predictability and value to their clients. It's my pleasure to welcome Christopher Anderson to the podcast. Welcome, Christopher, and thank you for being here.
Aniket, thank you. I'm real pleasure to be here and to share this information with your listeners.
I'm sure they're looking forward to it, and I know I certainly am. But before we get into that, I love to start each episode by asking each of my guests to share either a fun fact about themselves or a cringe joke. So which will it be for you, and what is it?
I'm not good at the cringe joke. I wish I were better. I'm not British enough. I think the most fun fact, because it explains a lot about me, and it's not cringy at all, is that I went to school as an astrophysics major. And, so because it's always funny to me that lawyers are like, oh, I'm a lawyer because I didn't want to deal with numbers. I love numbers and science. And I've really, I think that's been an important part of why I've done what I've done. But so, yeah, astrophysics major, still am fascinated by it, by astrophysics and what we're learning and continue to learn today about the cosmos, both large and really, really tiny. We're learning some very interesting things right now about what's going on inside of atoms and nuclei. So that's my fun fact. I'm a nerd, and astrophysics and physics are my jams.
That's amazing. As someone who's not quite that much into the hard sciences, I'm a trained chemical engineer from way back when. I appreciate the STEM focus, and I really enjoy having conversations with those who made that transition from STEM into the law in whatever way they did. So that's awesome. Thank you for sharing.
Yeah, I don't know.
So with that, that's actually a great segue into my next question, which is I think of every guest who makes the time to be on this podcast as a superhero, and every superhero has an origin story. And I would love to learn yours, especially as it relates to your entry into law from your astrophysics background.
An origin story, yeah. I really like the Superman one. Isn't that cool? Came on a meteor that's actually a bassinet. I mean, that's the best story ever. Mine is much less inspiring. I made the joke that, a lot of lawyers say they came into this business because they didn't want to do numbers. Well, I exited the astrophysics major because third year differential calculus made me realize that maybe at the end of the day, that wasn't going to be the level to which I wanted to go. And so I began to search for other means to use the scientific method and scientific thinking. And I actually entered into law through business. And that's what's really been the through line for me. So that's my origin story in a sense, is that my first job was not bringing legal knowledge to science, but bringing science to legal. I worked for a software company. We developed software to help with insurance companies and law firms to crunch large amounts of data before AI and to see and notice patterns in that data to help understand what was going on with mass torts, with large chemical spills, large gas emissions. And then I started to iterate on that because I learned a lot about, that's right out of law school. I learned a lot about business there and software, and then I kept bringing that back. So I then brought that back into the practice in the DA's office, would introduce, believe it or not, it's not like this was the 70s. In the 90s, introduced computers to the New York City DA's office, then back out into software company, then back to law, and kind of this back and forth between business and law. And because I did that, I was constantly, while in the business side of things, looking for and learning about processes that and systems that were not being used in law firms, because law was a profession, not a business, was the mantra. And then bringing those systems, tweaking them so that they matched the profession and the needs of the profession, and then helping law firms grow, change, iterate, evolve because of being able to operate more like a business, which at the end of the day actually serves your clients better, serves your team better, and serves the owners better when you do that. And so that, that's sort of a long-winded answer to the origin, but the origin really for me was the constant shift between business and law until finally, over the past, I guess for the past 14 years or so, I've had my one foot firmly planted in law, the other foot firmly planted in business, and am existing in both spaces simultaneously. And that's really brought the most synergy and the most power to what I'm able to bring to law firm owners and to help them grow their businesses.
That's amazing. If I may, if I may crack an astrophysics joke, you're like the Schrodinger of business and law. You're in both you're in both states at the same time, and which is great.
That's all funny until the cat dies. Then it's not funny.
That's right. That's fair. No, that's great. That's fascinating, Christopher. Because jokes aside, you're both an outsider and an insider, because you can bring that outsider's perspective from, hey, here's how the rest of the world operates and why doesn't law, as well as you have the credibility of someone who's actually practiced law and has a law degree, etc., to actually bring that to your peers, as it were. So that's great. Let's maybe talk about your the moment that you specifically decided that, hey, you know what, you've seen law, you've practiced law the traditional way, you've seen obviously others practice law the traditional way, but now obviously you advocate for maybe transitioning away from the billable hours. So was there something specific that triggered this, or was it a slow realization over a period of time? Can you walk us through that?
Oh, it's not been slow at all. Back to your, I want to I think you hit on something I want to make sure I emphasize, and it helps to answer this question too. I've always had a very deep need to test, back to the scientific method, right? Every idea I come up with, every nuance that I have brought out of business and said, hey, this would really work well with law. I think there's a lot of people out there who form these hypotheses and then bring them out as if they're truths. And I think there's real danger there. And I want to say that because the answer to the billable hour question that you just asked is another one where there's huge danger. And so I've been insistent on trying my hypotheses on myself first. Now we can call me the Jonas Salk. of law firm business. But yeah, I'm going to take the polio vaccine first. And not all those ideas have been successful. I have fallen on my face a lot of times. Some ideas have not been successful, including this one about the billable hour. I have had to iterate that, learn from the mistakes, learn in very difficult, painful parentheses. Hopefully my wife's not watching. Expensive, really expensive mistakes to find the truth, because that's how the scientific method works. Most hypotheses are disproven. Science is a process of disproving things, not proving things. And so that we came to this. But I just kind of wanted to emphasize the fact that like a lot of what I talk about, I don't really talk about publicly until I've tested it. But so you asked, did I come slowly to this? No, I didn't come slowly to this. It's apparent. And you know what? I think it's apparent to almost every lawyer practicing that bills by the hour that it is terrible. There are some practices where I think it makes some sense. I think transactional work, it might make some sense. But generally speaking, I'm not sure there's ever been a person in the history of the world that has really ached for an hour of an attorney's time. Maybe their spouses, right? They just wish they'd spend more time with them. Maybe that. But other than that, our clients do not want our time. Like one of my most hated phrases in the world is "thank you for your time." I don't think you can thank me enough for my time. You can't pay me enough for my time. In all the things, and this is where the crux comes, and I think everybody kind of knows this, but they don't know it. They haven't articulated it. Time is the only thing any of us has that is not of infinite availability. It is the only finite thing in our lives. We don't know when we're going to die, but we know that we will. And, if depending on your belief system, there may be a supreme being who already knows. You may believe that your date is already written. Some people don't believe that, but we all know that date is coming. So here we have this thing that is of finite availability, and we sell it for money, which is not of finite availability. We can all create money at will. That's what we do. And so we go around selling time for money, and then we wonder why things are broken. We trade the thing we have a finite amount and trade it for the thing that exists in infinite amount. That's a bad trade in anybody else's book. Now, that's bad for us. And I wanted to start there, right? Because unless I can show people that it's bad for us, the impetus to change is smaller. But it's also bad for the clients. Now you see behind me, I've got one of my brands behind me, Newly Family. Think about family law. This is true of all areas of law. If I, as the attorney, know, because it's true, that if I find more things about which I can create drama, that I can create conflict, that I can create a fight, that I can create motions and discovery and litigation, I make more money.
The arsonist becomes the firefighter.
Yes. Yes. And it's still a bad trade for me. So I'm not doing any better because I still only have a finite amount of time. So really, I don't have to sell more of it. I don't have to create more drama for you because there's the next guy coming down the road. I could create more drama for him. but it's also bad for the client because now, yes, I love it. The arsonists, the firefighters become the arsonists. I am now not aligned with my clients. Some of my clients want more drama. Maybe I'm aligned with them a little bit, but most of them want a solution. And the billable hour does not incentivize quick solutions. I'll never forget when I was first starting to practice, I came into a law firm and the senior partner was telling me about when he was an insurance defense lawyer and he had this huge case. And like he had several lawyers, but this case was occupying his whole team for months and months and months, into more than a year. And then they settled. And everybody around him is like celebrating, yay, we celebrated the case. And he's going like, oh shit, we celebrated this, we settled this case. Now we have to go find something else to do. And that's sort of like, this is what's wrong with the billable hour. It's totally, the clients were happy, but the lawyers' incentives, what made the lawyer happy was not aligned. And like I said, nobody actually wants an hour of an attorney's time. And think about this. Where else do we buy professional services this way? Nowhere that makes us happy. I broke my jaw when I was a kid. I didn't want to pay the dentist by the hour, or the endodontist, the oral surgeon by the hour to fix this problem. I just wanted my jaw fixed, right? Imagine if he charged by the hour and like it was like taking his time to get that problem fixed. That wouldn't work. But we don't pay our surgeons that way. We don't pay our doctors that way, really. We don't pay our auto mechanics that way. We don't pay anybody else that way. There is a fix and a price. There are very few professions where we really charge by the hour. My CPA for my law firm charges me X $1,000 per tax return, and charges me a monthly fee for ongoing advice. We don't talk about, oh, you talked to me for an hour, so I got more great advice from you. Please get it to me in 10 minutes. And so, so you say, did that come to me gradually? No, this always seemed wrong. This always seemed conflictual. What came gradually is how to fix it, because this industry is so married to it. It's so deeply, I mean, from what we're taught, from the law firms that teach us to the regulators, right? The bar really doesn't, most state bars, I shouldn't say all, because some are being progressive about this, but most of them really don't know how to evaluate legal work by anything but the billable hour, right? So when a client, when there's a complaint or when there's an issue that comes up that goes to the reasonableness of the fee, the courts always fall back to how many hours did it take, and that props up this system. Even New Leaf Family, where we do not charge by the hour, because we know that that's how we'll be measured someday. We keep the time, and we make sure, and we also have other things in place to make sure that our fees are reasonable in the context of the time spent, which is unfortunate, right? And but so the solutions came gradually in that there is a way to do a flat fee in a lot of cases. There is a way to do non-billable hour work that makes sense for the clients, that makes sense for the lawyers, where you're not trading your time for money, and most importantly, aligns the lawyers with their clients. And that's what what I am preaching to anybody who'll listen.
Thank you for sharing that, Christopher. That was that was an amazing sort of articulation of how you came to this realization. For the benefit of our audience who may not actually know, they're mostly attorneys, but they many of them likely practice billing by the hour. But for those who don't know, who may not know the origin story of the billable hour, where did it come from? Number one, and why is it so hardened in the legal profession, in your opinion?
Yeah, I can't answer the second question. I mean, I gave you the artifacts, right? It's how the bar measures things. but I think it's a little bit circular. It's how the bar measures things because now it's how we've done it for a really long time. In my first law firm that I went to work with, the senior partner of that firm had a legal bill framed on the wall. And it always stuck with me. It was handwritten. It was on a smaller than 8.5 by 11 piece of paper. It's kind of paper I don't ever see anymore. But think about it like as a kind of hotel stationery size, right?
Mm-hmm.
And it had a lot of words like, I did this, I did this, I did this. I did this, I did this. It was actually quite a lot of writing in a paragraph form, then a space, and then handwritten for services rendered. I think it was $350. And this thing was from, I think, was the late 19th century. So it was a lot of money. I did these things. Here's your bill. Kind of like your doctor's bill. Right? I did, if you go to your doctor's office, you pay your copay. You pay the amount. But you also know in your doctor's office, and this is going to answer your question, that behind that copay, if you ever look at your explanation of benefits that you get from your insurance company, that they've line itemed everything, including hours spent. That's where this came from. Before the 1960s, nobody billed by the hour. Nobody. But insurance companies were starting to pay lawyers more and more money to defend cases. And they began to have shareholders who demanded transparency and accountability and efficiency and profits. And so one day the bean counters and computers came about, which is a very important piece of this. And they said, well, we need a way to measure whether our law firms are doing a good job for us, whether they're being efficient. And they came up with, well, the only way we can think of to do that is by the hour. And so we're going to have them create bills by the hour, and we're going to have them code them in a way that the computers can read them and then tell us whether they're reasonable. And so the billable hour was born in the insurance defense part of the business. Well, then who else was a huge consumer of legal services? Large corporations, general counsel. And general counsel got wind of this and said, oh, not only does that look really good, but they've now written the software and created the billing codes, leads, that we can use and create a measurement of our outside counsel that we can hold them to. And so now it's now leapt out of insurance into business. And then, where are most lawyers trained? Well, most lawyers go through a larger firm before they go to a smaller firm, and it just started leaking out. And everybody starts doing it. And then the bar starts doing it. So but it all comes from insurance companies needing a way to measure law firms. This was never meant for consumer-facing law. This was never meant for family law firms. It never really came, interestingly, never came to criminal law firms for the most part, and stayed away from some other practices like estate planning, right? Where it just never really crept in. But it crept in places where litigation happens because that's where it was really born and where it was meant to measure. And then it just stuck. And nobody really asked the question about, is this good for the clients? And to my chagrin, because I work with lawyers, nobody asked, is this good for us? And it's not. It incentivizes all the wrong behavior, including working more hours in order to earn what we need to feed our families and protect our future. So I think I ranted. I think your question was, where did it come from? That's where it came from.
That's again, thank you for sharing that. And I really mean that, because I don't know of another example where the billing mechanism for a profession came from outside that profession, which is essentially what you're saying, which is and why would that be aligned with the interests of that profession if based on that story? So that's fascinating. So now let's talk about you. You mentioned you speak with and work with attorneys across the country. You also interview them on your podcast, the Un-Billable Hour, which I would encourage everybody to take a look at. I skimmed through a couple of episodes and they're fantastic. But when you speak to these law firm owners, Christopher, and when you tell them essentially, some version of what you're sharing with us for our audience here today, to move away from this hourly billing and how it doesn't really benefit anybody in your view, what is their reaction? What are their mental blocks? What are their fears? How do they what do they say when you tell them that?
Well, generally speaking, lawyers fear change, right? So there's that. And so just to be clear, I work with law firms across the country to help them improve their businesses. And I have this conversation with them, but most of them still bill by the hour. I'm not trying, I'm holding the door open. I'm not pushing anybody through it. I have found, like I told you earlier, like when I get good ideas, I run them through my business. I also use my business as an exemplar, right? I believe the best proof is in what the market says it wants and what the result is. So, we brought this to New Leaf Family only 5 years ago. 5 years and 3 months. We launched New Leaf Family as a subscription-based family law firm. A few firms have followed. Not many. They will, because the clients, the market loves it. But it's dangerous for the lawyers, right? There is risk to figure out what the subscription should be and how you should apply it and how you treat the clients in it and how you make sure it's fair and reasonable and how you make sure it's ethical. And we've spent a lot of time and a lot of money developing that so that it works, but it works. And the clients absolutely love it. We have grown to be, I think we're the third or fourth largest family law firm in Colorado. And we're not showing any signs of stopping, and we're going to be, going to a state near you. And, you got a couple of choices. You can fight us, you can follow us, or you can join us. Like, cause that's, but I'm open with it, right? I share this knowledge because I think it is aligned with what our clients want, and it makes lawyers' lives better. A lot of the lawyers that work now at New Leaf Family used to have their own practices. They make more money. They take home more money. They are happier, and the clients are better served here. And that's the proof I just bring to the marketplace. Is like I just prove by doing, and then I come on shows like this, or I speak on stages and tell the story about how to do it. But it's, you have the numbers, you have the knowledge, you being your audience, you're the people listening, on how to do this. You may need someone to help you put that knowledge to work so that you could figure out what this looks like in your jurisdiction, in your neighborhood, with your client base, so that it's aligned with your ideals. But it can work. I've proven that. And so now I just help people put it in place.
That's a great point. Series of points that you made there, Christopher. One term that you mentioned in that last segment was the term risk. And so a corollary to that is things that I've heard attorneys say, which is, hey, litigation is too unpredictable. Cases could settle in a certain amount of time. They could settle in a week, but they could go on trial for years. And therefore, by extension, the hour is in my mind, Mr. or Mrs. Attorney's mind, the only way to sort of mitigate that risk as best as I can. What is your counter to that?
Twofold. One, like I said, I speak on stages a lot. I work with large groups and with individuals. And one of the most fun things that I run into is when I come to a lawyer, I say, well, of all your cases over the past year, what's the average case value? How much revenue does your average case bring into the firm? And to a person, they will answer with a range. Oh, $7,000 to $15,000. And I get it. Again, we're lawyers because we don't want to do the math thing. But guys, the word average, it has one answer. It's not a range of answers. There's different kinds of averages. You could have the median, you could have the mean. We could get detailed, but there's one answer. Or maybe you could answer, oh, the mean is, but the median is, which is actually two very different numbers in my business. But there is one average. So, to your point with the litigation has risks. I mean, it has variations which create risk, and it absolutely does. But you do know what the average is. So you can already mitigate risk in your business by knowing that. That means you might put more time in than you got paid in this case, and less in this case. And then you can also inject contingencies. If it doesn't go to trial, it's this. And if it does go to trial, we add this. Oh, but it might be a longer trial. I know, but there's an average, right? And you can say, well, in these, you can price it by kinds of case. There's so many ways you can skin it by getting a little bit of knowledge and doing a little bit of math. And that you can reduce risk. Are you eliminating the risk? No, you are not. You are actually, when you do a subscription level business, you are moving some risk from the client to you. But I think that's what we should be doing, because we have the information and they don't, particularly in consumer-facing business or law firms, consumer-facing areas of the law. We have a very uneven playing field when it comes to doing business. The client has no information or very little, and we have a lot. So I think it makes sense to move the risk to us because we're the ones who are capable of mitigating it. Moving all the risk to the client is moving the risk to the person who can't mitigate it and who's being driven by emotion and fear and other things to spend more money that does not serve them. We mitigate the risk also by changing. We have two fundamental differences. We've been talking this whole show about one of them, which is moving to a subscription model. It's not the only model, by the way. Flat fees work, product-based billing works. There's a lot of other ways. We've been talking about one of them. But then the other thing, changing the billing model is one. The other one is we change how we practice. We change our focus from what can we do or how can we win based on our definition of winning, which is how most lawyers do it, to how can we help the client achieve their goals? And clearly articulate those goals in such a way that everybody is aware and knowledgeable about what they are so that we can move towards them. That's an important part of the sauce to mitigate risk. Because once you get the goals clarified, you are cutting off certain avenues of attack, certain avenues of spending time and money to achieve the goal, which is good. And as long as the client's aligned with it and the client is fully informed, it's good. And then you just, for the rest of it, you accept the risk, but you also accept the fact that averages mean that things even out. And so you accept that risk and with the knowledge that things will even out, and they do. And quite honestly, like if I hadn't been practicing for 24 years before I tried this, it probably wouldn't have gone as well. In fact, the truth is, in my second year of private practice, I tried a flat fee service. Disastrous, as many are, because I didn't have the data, I didn't have the information, and I didn't know how to build the systems around it. Our subscription billing service is not simple. It's complicated, but it's explainable, and it works. And like I said earlier, I mean, I think just to bring it back home, it works for the clients. It aligns us with the clients, and it works for the lawyers, and it aligns the lawyers with doing really good legal work because we're no longer tied to a metric that doesn't serve anybody.
That's great, Christopher. There's a couple of things that really stood out from that for me. One is the practical take home that, hey, every risk, for any individual lawyer who's been practicing for a certain period of time, there is an average, and that average sort of can anchor that individual lawyer and their practices as to where sort of they stand in terms of their business model, so to speak, on the in terms of how they built. That's number one. But the more profound sort of abstract insight that you shared, which I thought was really, I haven't ever thought of anything in this manner that you just shared, which is that they who hold the asymmetric information are also in a better position to absorb the risk. I think that's a fascinating insight, and I think there's a lot there, and so I really appreciate your sharing that. You mentioned New Leaf a couple of times, and you mentioned your subscription model. Can we maybe take a little bit of a detour and talk about that part of your professional world and what you do at New Leaf, and maybe dive a little bit more into that subscription model that you mentioned?
Yeah, so I'm happy to talk more about New Leaf. I'll answer questions about the subscription model, but I want to be very careful. This is something that, as I mentioned earlier, I work with a lot of law firms. I am the strategic business advisor for a bunch of law firms across the country. And one of the first questions when I'm on stage or when I first start working with a client, and it doesn't matter what we're talking about. We could be talking about percent of income that we pay to payroll, or percent of expenses that go to rent, or what the best closing rate is for consults, or a bunch of other numbers. And people always ask, well, what number should I be working towards? And that's why I want to be careful to talk about the subscription model, because the answer is going to be the same. And by the way, folks, it's the same answer you give clients when they ask you questions. Depends. It depends on your market. Where are you in this country? It depends on your clients. Who do you want to be serving? It depends on your courts. How complicated do they make things? How much work do they make you do that you have to kind of account for? It depends on your style. How do you practice law? It depends on all these things. So the answer is unique to your business. And so I'm not going to talk about numbers, because God bless them, someone out there is going to go and say, Anderson told me if I charge this much, then this will work. And so I'm not going to do that. New Leaf Family, I think New Leaf Family serves clients right now in Colorado. We're about to branch out to several other states. And by the way, we have to refigure this out for each jurisdiction we go to. And so I talked to lawyers and practitioners in those states to figure out the numbers that I already knew when I started this. And I knew how to figure it out. But so, I figure this out again every single time. I can help you do that. I can help your listeners do that, but I've got to help them one-on-one. And so we serve clients through every area in family law, but we do it all on a subscription-based model. We help clients who have very simple cases with one kind of subscription, and we help clients with very complicated matters with a different level subscription. And we assess them based on their individual characteristics. So we have a model that we apply so that we can figure out the price for each client based on their individual characteristics of their case. And it took, that's the secret sauce. That's what it took so long to get right, is to be able to figure that out up front and use the word average into a very much more finely tuned algorithm that helps to set that. Everybody here can do that, but you might need help setting it up. And that's how I can help people do that. I obviously can't do that on a 1-hour podcast, but it takes some setting up and some doing. But the payoff is happier clients and happier team, and at the end of the day, happier law firm owners, because it all actually, even though we bring on risk, it all actually becomes a lot more predictable. And then, and the clients love it. The clients absolutely love it. Does that
That's
you're asking?
Yeah, no, absolutely. And then that's actually fascinating because for me, listening to you share that, Christopher, my takeaway is that, hey, if for an attorney who's listening, they are right in that there's some level of risk involved in the matters that they take on. However, with the models of the kind that you've developed for your own firm and that you develop for other law firms, law firm owners across the country, those models serve to mitigate that risk, which then enables this non-billable hour sort of more incentives aligned billing structure, which makes a lot of sense. So did I get that right?
Yeah, no, that's exactly it.
That's great.
That is exactly it.
Awesome. Let's now shift to the elephant in the room, right? Especially today, especially over the last 3.5, 4 years or so, which is AI. And so, your sort of realization around the billable hour and its suitability or lack thereof for a lot of areas in legal practice obviously predates AI, but now AI enters the conversation in pretty much everything that anybody does. And so, given that so many different applications of AI can do in minutes what would take hours maybe for a junior associate or an attorney to do, how does that affect this whole conversation, the whole thesis that we've been talking about for the last 40 minutes or so?
Profoundly, but not in the way most people think. And I'm concerned because most people think about this the wrong way. Most people that I listen to that are talking about it are running around concerned that this will gut the legal profession, that AI is coming for lawyers. And that thinking has a premise that is fundamentally incorrect. And that is that the completion of forms, the administrivia of the law, also known as a lot of what we do, is what's valuable about this practice. And you know why they think that? Because the billable hour teaches us that. Because you know what? Our billable hour rewards us exactly the same for completing a settlement agreement or a memorandum of understanding or a brief that is a lot like the other briefs we did already, for calculating child support, calculating alimony, for calculating a sentencing guideline, for drafting a business agreement, for pleadings, for defensive pleadings, for plaintiff's pleadings, for so many things. That's, like you said, you mentioned, say some people have associates do, right? Some people have paralegals do, but we bill hourly for this stuff. And we pretend that that's the practice of law. It's not, and it never was. And then we say, it's coming for us. No, it's coming for that. But then people, I'm going to walk you through the thought pattern because it's really important. So then people go like, well, if it's coming for that, and that's most of what we do, then it's coming for a lot of us. And to me, that just is so sad to be thinking that way because it ignores what's really about to happen. What's really about to happen is we're going to be able to serve people better. The truth is that we can't serve people the way they want to be served in the current model because they can't afford it. Or we can't afford to. It's two sides of the same coin. If we put in the time that is required under the current system to serve people the way they'd really like to be served, with the depth and the empathy and the understanding with which they'd like to be served, either they'd go broke or we will. So we live with and we accept and we tolerate a level of service that's given us the reputation that we deserve. That's what AI can do. AI can liberate us from the stuff that's not really the practice of law and can enhance our ability to do the service to a level that even without all that trivial administrivia, we couldn't do. We're going to be able to serve our clients so much more deeply, so much more completely, with so much more holistic knowledge applied to how we treat their case and treat them, that it is going to revolutionize this profession. It's going to restore what I think was the most honorable title we've ever been given, and which we've stripped from most of our business cards, which is attorney and counselor at law. We get that back, and our clients get that back. And if that's where people take this, ain't no AI coming for us. It is going to be this magnificent, one of the many that have come along, tools to help us, but it's going to help us in a way that none of the others have. That's what I see. And so, when Richard Susskind wrote his book, The End of Lawyers, most people forgot that title of his book had a question mark at the end. It was the end of lawyers? And the answer is no. It's just the beginning of the end of a dysfunctional system that doesn't serve lawyers, clients, or law firm owners. And the introduction of basically my dream of a system that does. And how cool is that? Joy, the practice of law can be joyful, and the joy is coming. And I'm trying to be a force to, I'm not an AI engineer. I don't know how to build AI, large language models, but I know how to implement them to benefit the three constituents that I've been talking about. And that's my mission.
That's amazing, Christopher. This has been an absolutely illuminating conversation. Just a couple of final questions to wrap it up here for us. So, practically speaking, for the law firm partner or owner, who's listening to us right now, who's listening to you right now, who's burned out on this whole, billable hour grind, they sort of feel maybe that it's not the right thing to be doing, but everybody does it, so they have to do it anyway, and maybe they feel trapped by their firm's legacy systems. What is the very first step that they can take tomorrow to start transitioning their practice to a better model? Maybe step 2 or 3 is reaching out to you, but what is step 1?
Step 2 or 3 might be reaching out to me, so thank you for that. Step 1 is learn. If you aren't using if you haven't had conversations with a large language model, start. If you haven't learned yet the difference between generative AI and agentic AI, Google it and learn it. If you haven't been checking out the tools that are commercially available to help with various aspects of your practice, to start to bring, you don't have to build this stuff, to start to bring those capabilities to you through commercially developed and vetted products, get one. Some of them are expensive, but very, very useful. Like, I think it's Alexis's, I think it's Prodigy, Westlaw's Co-Counsel, Harvey. look into them. But the first step is really like, it's not magic. Just start using it. And then, yeah, I think, then start learning from others who are a little bit farther along the path than you. And so you don't feel like you have to reinvent the wheel. This is not, it's so funny to have this conversation, right? Because let's take ourselves back 28 years and go like, oh man, we're going to have to learn the internet, right? But that's how people felt because it was this new tool. We didn't know how it fit, how to use it. And so we felt like we had, when I told you like at the beginning of this conversation, like my first job, I wrote software and helped insurance companies and insurance defense lawyers implement that software to detect patterns. Well, part of that was actually teaching people how we taught a course in that called keyboarding. We taught a course in that called mousing. Like, we had to teach people to use these tools. Nobody thinks about that. They're extensions of us. Then, came along Steve Jobs. Did anybody teach you how to use one of these?
Nope.
When my kiddo, who's now 18, was 4, I didn't have to teach him how to use this either. 20 years from now, nobody's going to be like, oh, I got to learn how to implement AI. You're not even going to see it anymore. We're at that beginning phase. But for the law firms that want to become everything they can be, then it's got to become as second nature as a keyboard and a mouse. And the way you get that is start using it. That's it. And one last thing. This is very important. Do not use the free stuff.
Yes.
I want to say it really loud. Do not use the free stuff. We have obligations as attorneys to confidentiality and privilege. You have to make sure that the tools you use are meeting that obligation by not using the stuff that you share with it to learn on. The free stuff does. Always remember, with any technology, if you're not paying for it, the product is you. You are selling your client's information to have access to this tool. Don't do that. You can't. But some people don't know that that's what's happening. They just think it's free because, OpenAI and Anthropic are just, remember, Anthropic is Anthropic. It's not philanthropic. It's just Anthropic. It's a business. They're a great business. I love them, but use the professional grade stuff that protects your client's privacy. Just wanted to make sure we didn't say that anywhere in the show. That's important.
Absolutely. So in terms of resources, obviously, it's great advice, I think, to tell people to just go out there, jump with both feet into the water, as it were, and test it out for yourself. In addition to that, what resources can help people sort of understand better what they're diving into? So obviously one would be, your podcast, the Un-Billable Hour. But what is something else outside of that will, in your opinion, help sort of the legal professionals who are interested in sort of pursuing this path, understand both the realities of the non-billable hour business model as well as of AI, and the two are, inexorably intertwined at this point? What is your suggestion there?
Oh, I don't. Yeah, I mean, actually, I don't think they are intertwined at all. I think the one exists. The lack of the killing of the billable hour. Remember, the billable hour, the law existed without the billable hour long before calculating machines were brought to be. So not intertwined at all. It is an accelerant, an enablement tool. But so listen to, where can you go? You listen to my podcast, go to seminars, learn from people who know what they're talking about. But let me just also warn you, there's so many people now, like some people like used Claude for a week and are now teaching seminars on Claude for lawyers. Don't. Anthropic just did a Claude for Lawyers webcast. I think it's available as a recording. Go listen to that. Listen to people who have really been using it, for a long time, which in this world is like 3 months. Be careful who you trust, who you listen to. And I'm not trying to blow my own horn here. I don't work with that many clients, but work with people who are doing it into their own businesses already at a level that is beyond yours. And do remember, there's no gurus. This stuff is literally, agentic AI is months old. Large language models are years old, but how we're using them keeps evolving, keeps changing. Just keep learning. That's all I can say is keep learning. And if if you want, learn from someone who's committed to the result that I was talking about, and not committed to the result of, wow, this could replace all our people. Because that's a wrong result. That does not improve the world. And this is a tool that can really improve the world.
Absolutely. Final question for you, Christopher. Is there a question that I should have asked you, but I didn't?
Oh, gosh. There's 100. We didn't even talk about the new knowledge about how beta decay is proving that muons may be existing in two universes simultaneously. Like, we didn't even go there. So you could have asked that. There's so much, but no. I think we've covered a lot of ground here today. And I hope it's been valuable for you, and I hope it's been valuable for your listeners. Thank you for the opportunity to expound.
Absolutely. It's been valuable to me personally on many levels, right from the profound and the abstract, such as some of the insights that you shared, right down to the super practical, tips and guidelines that you had for attorneys. So thank you very much for your time, Christopher. Really appreciate it. I'm sure our audience will learn a lot from this. So I thank you again.
You bet. You take care.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.